Most people have a story about a nightmarish situation involving a landlord and a tenant. And most people either were or knew one of those parties. Conflict over a rental arrangement is common, and the best way to avoid it is to sign an airtight contract. But many tenancies are at will, meaning that they're uncontracted. There may have been a conversation between a landlord and a tenant, or there may even been a written arrangement, but there's no formal lease agreement that specifies when the arrangement ends. In this video, we'll cover what a tenancy at will is, the rights of both landlords and tenants engaged in a tenancy at will, and how a lease agreement can protect you from costly litigation. We're eForms, the world's largest online database of fillable legal forms. Be sure to watch till the end of this video to access forms that can help you to navigate the complicated world of tenancy and housing. So what is a tenancy at will? First, let's talk about the other forms of tenancy so we know what it isn't. The first is a tenancy for years, which is a tenancy governed by a formal lease agreement. Another is a periodic tenancy. This also involves a legally valid lease agreement but does not specify an end date. Then there's a tenancy at sufferance. This is a fancy way of saying a lease ended or expired and the tenant didn't move out. If the landlord continues to collect rent, the court considers the tenancy valid. The fourth type of tenancy is called a tenancy at will. In a tenancy at will, the tenant has permission to be on the property, but the agreement is not governed by a formal lease. The agreement gets renewed every month unless either party indicates a desire to end it. So what happens if a landlord wants to end a tenancy at will? Because of the complicated and variable nature of rental laws, removing a tenant is not as simple as asking the tenant to move and then changing the locks if that doesn't happen. It's always a good idea to seek other ways to resolve a problem before the problem winds up in court. Eviction costs time and money. However, sometimes a landlord and tenant don't reach an agreement. In this case, the landlord can issue a notice to quit. While requirements vary by state, the notice generally gives a tenant a time frame in which to either fix a stated problem or move out. If the tenancy is governed by a fixed-term lease, the landlord needs a legally valid reason to initiate an eviction. An example of this is non-payment of rent. When the tenancy is at will, the landlord has to provide notice but doesn't have to offer a legally valid reason for doing so. At the same time, it's also true that eviction can be a little bit more complicated when there is no lease. Leases spell out the time frame in which the tenant must be notified of impending legal action. If there's no lease, then usually the landlord is obligated to give a full 30 days notice. This varies by state. The primary advantage of a tenancy at will, of course, is flexibility. Flexibility, however, is the opposite of stability. People who consider a tenancy at will too risky or uncertain, or who want more control over a move-out date, might want to consider a lease agreement. For official lease agreements that meet your state's requirements, click the link below. And don't forget to subscribe to our channel to access other videos that simplify the complex process of renting or owning a home.